And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everybody. Thanks for joining me on short notice. I would appreciate everyone identifying themselves and telling me who they represent for the record. Why don't we start with Ms. Frizzoli?
Carol Frizzoli, I represent the Department of Children and Families.
Ms. Deely?
My name is Megan Deely. I represent the father, Damian S.
Ms. Brown?
Good afternoon, everyone. I represent the
Ms. Murphy?
Hello, I'm Monica Murphy. I am the Appeals Supervisor for the Department of Children and Families.
Ms. Carleen?
Margaret Carleen, Your Honor, representing the mother.
And Mr. Prescott?
Attorney Prescott, DCF trial attorney.
Okay, so there are three DCF folks. Who's going to speak on behalf of DCF?
I will, Your Honor.
Okay. And then Ms. Deely, you have the father, Ms. Brown, you have the child, and Ms. Carleen, you have the mother. Is that right?
Correct.
Okay. I perceive this as a joint motion by the mother, father, and child. Am I right about that?
That's correct.
Who's going to speak first on behalf of, and I don't want to, or nor do I mean to cut anybody off. Who's going to speak first on behalf of the petitioners?
Your Honor, with your permission, I can speak on behalf of all of the petitioners, unless you have specific questions for Attorney Brown or Attorney Carleen.
So I don't at this point anticipate that, but I may.
Okay.
And well, I probably will. Let's face it. It's your petition, so why don't you start? I will tell you that I have lots of questions.
Okay.
Many of them are factual. And I'm going to interrupt because that's my style, so get used to it. Yesterday we had somebody who was a little off screen swear. And so if you've got anybody sitting like behind you, you could warn them that that's not going to work because it actually gets picked up by the sound. Treat this as if you're in a courtroom. All right.
Absolutely.
Ms. Deely?
Thank you, Your Honor. Our petition lies on three grounds. Two relate to the lack of subject matter jurisdiction of the juvenile court, and the third has to do with the preponderance of evidence standard, which we believe was not met in this case. With regards to jurisdiction, our argument is that Massachusetts is not the home state of the child, who has always resided in Rhode Island, and Rhode Island is also the most appropriate forum because they have all of the information and evidence with regards to this case. With regards to the emergency provision of the MCCJA, that applies when the child is in the Commonwealth in the case of an emergency. However, the department did not even allege that there was an emergency in this case. They said, I'm quoting from the department's opposition on page 18 and 19, that even though the department response worker did not have any specific safety concerns, the department didn't have any verification of services from Rhode Island, no approved ICPC, and no way to ensure the safety and well-being of the child. So really their issue was the same as the trial courts, which is we just don't have enough information.
Where were you quoting from? Page 18 and 19 of their brief?
Of the 18 and 19 of the opposition, yes.
Right. You said there were two jurisdictional issues?
The second has to do with the pleading jurisdiction of section 24, that they must allege that the case falls within one of the four statutory grounds, but the department doesn't allege any information to meet those grounds.
Why is that a jurisdictional issue as opposed to just not having pleaded properly a claim?
Because I think it's Care and Protection of Lillian sets out and states that it is a jurisdictional issue. It is a matter of subject matter jurisdiction.
How can that be? What case says that?
Care and Protection.
Yeah,
of
what's the
Lillian.
site?
Yep, 1 minute. It's 445 Mass. Sorry, at page 337, note 9. Let me get you the full site. Mass 333, 2005, at page 337 and note 9.
And what is the statute that I need to look at? Remind me what that is for the jurisdictional issue.
With regards to Rhode Island and Massachusetts?
Yeah.
Sure, that's GL 209B.
All right, I'm just going to pull those down. Give me a moment, folks. Okay, 445. All right, is the microphone so bad? 445 Mass? Yeah, okay. All right. Let me ask you some. Child was removed on the 2nd of November, correct?
It was the.
That's what I have here.
It was actually the 30th. So the Rhode Island Family Court returned custody of the child to her parents on the October 29th.
And then on the 30th, the child was removed?
Yeah, by the department. On the 2nd, the petition was filed because the department removed it as a supposed emergency removal.
Right. Okay. So the child's been out of the custody of the parents for over 2 months. What's been happening?
I can let Attorney Brown answer that question as she's child's counsel.
Yes, Your Honor, the child is remaining with maternal grandmother and maternal great-grandmother in the state of Rhode Island and Pawtucket in her home. They were trying to get her into daycare. The department and relatives couldn't agree to a daycare. She was on a list for Montessori school. Parents were visiting every single day, doing a great job with that. Beyond that, it's her daily schedule.
Okay, so she's 2 years old?
Yes, just short of 2.
And she's with maternal grandmother in Pawtucket, and the parents visit every day.
Yes.
And that's what's been going on for the last 2 months.
Yes.
Is that right?
Yes.
And I take it mother, father, and child all want this order overturned and want the children, want the child to be returned to the custody of the parents and not the custody of DCF, correct?
Correct.
Yes, Your Honor.
The department would, of course, be able to keep an open protective case and provide services and supervision of the family, but we're asking that the custody order be overturned because of, as you stated, lack of jurisdiction, because Rhode Island really is the proper jurisdiction for this case, and also it's a pure insufficient evidence. The court said in its own words, I just don't have enough information to send the child home today. Per Care and Protection of Aaron, the burden never rests on the parents to prove that they're fit. The burden is always on the department to show that the parents are unfit, although the standard at this hearing is immediate risk of serious abuse or neglect such that removal is necessary to protect the child from same. And the court just said, we just don't have enough information. Well, that's unfortunately, that's not enough. The court has to have evidence in front of it showing that the child is at.
Where does that standard come from? That's a statutory standard. Immediate risk of serious abuse and neglect. Where's that from?
Sure, it's both. I mean, it's section 21, chapter 119, section 24, but it's also care and protection of Robert.
Okay.
And it's a due process constitutional requirement.
So let's just talk about jurisdiction for a moment. The DCF says, I believe, and I'm sure they'll correct me if I'm wrong, that this falls under 3. The child is physically present in the Commonwealth, and it is necessary in an emergency to protect the child from abuse or neglect or for other good cause shown. Right?
Yes.
Why doesn't that apply? Child was in the Commonwealth. DCF said that it was an emergency situation.
DCF says it's an emergency situation, but their own, the statements of their own investigator and their own records clearly reveal that it wasn't an emergency situation.
But there's another piece of this that I do not understand. Rhode Island had closed their case with respect to the child, right? And said they were releasing the child to the parents.
Correct.
Parents are in Massachusetts.
So the definition of a home state is the state where the child has resided concurrently for the past 6 months prior to the assumption of custody, and the child has resided in Rhode Island.
Right, so
the
why
child's
would
never
Rhode
resided
Island,
in
but
Massachusetts.
I don't understand why I would want to construe this statute so that Rhode Island retains jurisdiction after Rhode Island has said, I'm releasing it to somebody who's in Massachusetts.
Well, the statute states that the home state jurisdiction exists where the child's home state is with the state that is the child's home state, and that is Rhode Island, regardless of whether the parents live in Rhode Island.
Do we have that I have to say, that does not make sense to me. That does not make sense as a way to read the statute, and I'm going to spend some time with it. But you know, one of the first rule of statutory construction: do not construe a statute so as to render it stupid. And if Rhode Island has said we're giving this child to Massachusetts, construing it so that Rhode Island retains jurisdiction, I think comes perilously close to violating the first rule. But I'm not sure how to do this, because I understand your argument that there's no emergency and so it doesn't fall under 3. And yet it feels to me like once Rhode Island has said he's yours and the parents live in Massachusetts, that Massachusetts has jurisdiction. I'll have to think on that a little bit.
If I could just add that because it's a matter of subject matter jurisdiction, the Rhode Island court cannot grant home state jurisdiction to Massachusetts. While
not suggesting that they can. You're absolutely right about that.
The Rhode Island court could, if consulted, could decline to exercise its jurisdiction, but that never happened.
Right,
and,
no, I understand
and a
all
return
that.
of yeah.
I don't think this turns counsel on what Rhode Island did or didn't do,
Okay.
except for the fact that everybody agrees that Rhode Island has released the child to the parents. Everybody agrees on 2 facts. 1, Rhode Island released the child to the parents. 2, the parents live in Massachusetts, right?
Correct.
Do we have a copy of the judge's order in Rhode Island?
No.
So that's all sort of word of mouth. Is that right?
Right. It's uncontested, but yes.
It's uncontested that the judge said something to the effect of jurisdiction, I'm releasing the child to the parents.
He said that according to the record, the judge said that he felt the parents had done everything that they needed to do, and returned custody and closed the case.
Returned
Now, the
custody.
parents were entitled to take the child back to their home in Massachusetts.
And the moment they do that, doesn't Massachusetts get jurisdiction?
No. Only if there's an
Is the
emergency.
Commonwealth the home state of the child on the commencement of the custody proceeding if the child is with his parents in Massachusetts?
No, Your Honor, it would be, well, if there was an emergency, then they might
Forget
have
the
custody under
emergency.
Section 3.
I'm on Section 2A1.
The home, it still goes by the home state, which is the 6 months prior to the child's to the initiation of the proceeding, which is whichever state. And the child even was still living in Rhode Island. The child was still spending nights in Rhode Island.
Okay, so I'm living in Massachusetts with my 2-year-old. Okay, we're doing great, but we decide to move to Georgia. In Georgia, I don't treat my child very well. 2 days after I land in Georgia, I don't treat my child very well. The Georgia DCF has no jurisdiction.
Assuming that
Only Massachusetts does.
Assuming that, no, they would have jurisdiction to take temporary custody for the court to make a temporary order under Section 3, assuming you're applying the UCCJA or
because it's an emergency. But what if it's not an emergency? Georgia can't do anything about it? They can't initiate a proceeding?
They can call Massachusetts and ask Massachusetts if they will if they want to exercise jurisdiction or decline to exercise jurisdiction. And they may say under the circumstances, he no longer lives in Massachusetts. The family doesn't have any connections to us anymore. We don't want the case.
Where's the definition of home state? Is it defined in Section 1?
I believe it is in Section 1.
Well, that sure does seem to be what it says. All right, I have to think about that. I'll be hearing from DCF soon enough, I think. Okay. Ms. Frizzoli.
Yes.
I'm afraid I'm going to have some very pointed questions for the DCF. Don't take it personally.
None taken, Your Honor.
First question is, what do you say to the argument that there's no jurisdiction because this didn't qualify as an emergency?
Your Honor, the facts of this case, it does qualify as emergency in the sense that we had the department was put in a situation. They received a 51A report, which under the law, they have a duty to investigate from the Rhode Island social worker who told them that the Rhode Island judge had dismissed a case over their objection, that there were concerns about the safety of the home, the mental health of the father, and there was also concerns of the current custodian about the safety of this child in the placement of his parents. But what was really telling in this case is what Massachusetts had in its possession was a denied ICPC that had been performed in March of 2020. That was the one record that the department had on this family prior to receiving the 51A. That ICPC, which is part of the record in this case, details a very unsafe environment in the home, where there were wires hanging, there was boxes loaded up that could potentially fall on a child. There was there's a three different families or family members living in this house. They were in a basement, living with their parents.
Let's say I agree with you that report satisfies the notion that as of the time the decision was made, maybe you qualify as an emergency. I don't see emergency defined in the statute, by the way. what do you do with the fact that when the caseworker from DCF went there, her report indicates none of those problems?
Correct, but, and so the caseworker, contacted her supervisor, which I believe is in the 51B. Again, but we have a denied ICPC describing all this. And although the safety concerns might have
Right,
not
but
been evident,
the ICPC is from 7 months earlier.
correct.
And presumably it was provided to the parents. Apparently they took action to get rid of the concerns that had arisen in March. And now you have no contemporary evidence that there is a problem.
But what you don't have either, Your Honor, is an approved ICPC. And I think there's a case called Custody of Quincy, which talks about the Interstate Compact Act, which, in fact, in that case, it was.
What is the significance of not having an approved ICPC?
Because once you don't have an approved ICPC, state of Massachusetts can't provide services to this family. There is no, we don't know specifically, because it wasn't just the apartment. There was concerns about the father's mental health, whether he had done the psychological exam that Rhode Island had requested. It was about the entire family. It was a home study, not just the physical attributes of the home, but it was also about the.
What is the basis for telling me that Massachusetts cannot provide services to the family? Apparently they believe they have jurisdiction to remove the child from the family, but they don't have the ability to provide any services?
Well, Your Honor, if you look at the case of Custody of Quincy, which talks about this kind of similar factual where the child was in Massachusetts, the child was released to a father in New Hampshire. In that case, the son had no services. There was no ICPC done by the state of Massachusetts. So therefore, there was that's the overall law that governs all 50 states when you start transferring children across state lines. So it protects the children. And in that case, they basically—
Doesn't sound very protective to tell me that the child who's in Massachusetts can't be provided services in Massachusetts. That doesn't sound protective at all.
Well, again, we have an ICPC from Massachusetts, a home study, and again, not just a home study, but a family assessment, which says there are issues with this family. So Massachusetts does not accept the placement of this child. And yes, it was in March, but what we didn't have is an updated ICPC, which said the parents did everything. Because
what's the site for Custody of Quincy?
Sure. Custody of Quincy is 29 Mass Appellate Court 981.
All right, you're going to have to give me a moment. I'm going to read it. I have 28 Mass Appeals 981, and it doesn't look like Custody of Quincy.
It's 29 Mass Appellate Court. I'm sorry, Your Honor. Did I speak wrong?
I may have written it down wrong. A rescript, right?
Correct.
Yeah, I don't see it here, what you're telling me the law is. You're telling me something that, again, the second time today already, I'm hearing what law is. It doesn't make sense to my instinct as to what law should be. So I'll pay attention to that. But, you know, the notion that Rhode Island says it's time to release this to the parents. Parents live in Massachusetts. The child goes to Massachusetts. The notion that Massachusetts can reject that or somehow say we're not going to provide services because the ICPC tells us that that's the right result, I'm not buying it.
It's even if you look at the section which I attached of the ICPC, which I
read it.
Yeah, and it basically says in the receiving state, because like in New Hampshire, this father literally had to abandon his child at the hospital in order to get the child's services in New Hampshire because Massachusetts had not properly done the coordination of services.
But that was what New Hampshire did. You know, who knows whether New Hampshire did it right. What that case says is this is what quote unquote should happen.
Yes.
And that I can believe, but saying that it has the obligation of law such that Massachusetts doesn't have the ability to provide services to a child that's been released to them and lives in the Commonwealth because that's where the parents are, doesn't make sense to me.
Your Honor, it's just one of the factors of why the department considered this an emergency. But Your Honor, in addition, when we filed the petition was accepted by the court. Historically, so the petitioners actually, I think the parents filed a motion to dismiss the petition. The trial judge, because he had accepted that petition, he didn't have any leeway in order to.
Judge a he or a she?
She, I'm sorry.
That's what I thought.
It was Judge Souza. And so she didn't have once the case was accepted under 119 section 24, she didn't have the authority to dismiss that case or grant that directed verdict. But then she scheduled a 72-hour hearing, which, as said by the trial judge, is at that hearing, there was no testimony presented. All that was presented was the department's exhibits. The petitioners and that trial court at that 72 could have challenged all of this. And it wasn't done with any live testimony or any exhibits on the parents' part. So, and now we're here at the appeals court level.
Which way does that cut?
Well, again, Your Honor, it wasn't done. The purpose of the 72
Where does the burden of proof lie?
The burden of proof still lied with the department, and we can.
Of course it does, because as we've said, as a court and as the SJC has said over and over again, separating a child from a parent involves a very serious constitutional right.
Correct.
Okay? And one of the things you ought to do is meet your burden. And the burden is you have to prove that the child is at serious immediate risk of abuse or neglect. What is the proof of that here?
Well, again, Your Honor, there was the denied ICPC, which had a description of both the family and the concerns about the family.
But that is completely undermined by your own witness, who in October goes and doesn't see any of those things.
But what she also couldn't verify was the father's mental health. She had talked to the grandmother.
Why do we have to verify the father's mental health? Where is the evidence that the father had mental health problems that could result in immediate risk of abuse and neglect to the child? What is the evidence of that? The grandma said she thinks he was a schizophrenic? Because again, I got to tell you, that is not evidence.
But what we did have is the social worker, the Rhode Island social worker, saying the same thing that he had reported.
The social worker. So can we just talk about that for a moment? I have to tell you, this is why I'm really frustrated with this. I don't know what the right answer is, but I am frustrated with it. The Rhode Island social worker is sour grapes. They made an argument to the judge and they lost. And the notion that we're going to take that without a grain of salt seems to me to be the wrong way for the department to be operating. I mean, yes, she filed a 51A. Yes, you have an obligation to look at it, but to say that that's your evidence there's an emergency, that's someone who argued that to a judge and lost. from what we know, which is why at the top of this thing, I asked the question, do we have anything from the judge? It would have been nice to know what the judge was thinking. But, you know, the notion that that is serious evidence, I really struggle with that. And grandma who says, you know, she obviously doesn't like the father. I don't know whether it's right or whether it's wrong, but it also seems to me to be clearly not competent in a lot of ways. I think he takes LSD, and then somewhere in these records it suggests, well, you know, that's what we heard from her because he said it at a party. Is that evidence that he's a serious drug addict?
But Your Honor, what we had was the 51B report, which under adoption of Luke comes in for primary fact. And that primary fact wasn't challenged at the 72-hour hearing.
Well, wait a
so
second.
The evidence that we had was
the 51B report, is the 51B report the report of the DCF employee who went to the house?
Well, yes, the the investigator. Yes, it is, Your Honor.
Okay, and where in there is there any significantly competent evidence that either of the parents, yes, I guess you have the Coreys, which indicate that there are issues.
Yep.
I don't want to suggest that I know what the right answer here is on the facts, but the burden of proof lies with the department. And what you're relying on is a report from a social worker who apparently made these arguments to a judge and lost, a report from the grandmother who has been taking care of the child and admits she doesn't care for the father, and a dated report from ICPC, which apparently is undermined by your own employees' observations when they went to take the child. Am I right? Those are the three principal pieces of evidence.
Correct, Your Honor. Correct. And there was other, there was a daycare person contacted in our investigation who had worked with the family. I think Miss Grace, who basically said that although the family did work with her, that, you know, initially there were concerns with the father. But again, what we had was—
Where is that?
That's in the 51B, Your Honor.
Yeah, I'm looking through the 51B and trying to find it.
I mean, again, this isn't, the department's not going to contend that this is, you know, our strongest case. But it was a case, it was a case where we met, I mean, the burden of preponderance of the evidence, it's not a high burden. And that's why, you know, we went through and went through the process.
But it is a high burden that the child is at serious immediate risk of abuse or neglect. Do you agree that's the standard?
Oh, yes, I don't disagree.
Okay, well, that seems to me to be a high burden. Serious and immediate and abuse or neglect. 3 pieces. What about it was immediate? Just the fact that the child had been just released to the parents?
Again, based on what—
With no evidence of any neglect or abuse by the parents at that time.
What we had was a Rhode Island social worker telling us that the house was unsafe, that father had mental health issues that were unaddressed, and that the judge, you know, that over their objection and the objection of the CASA worker, the judge dismissed the case. Again, like you said, we have a duty to investigate.
That I understand, and I get that.
And we made the determination to remove the child, and then at the 72-hour hearing, we presented evidence that was unchallenged. And again, the judge agreed.
Unchallenged? That's not quite true. As I understand it, and I should have read, but as I understand it, the mother spoke and said that they—
Oh, no? She spoke at not as testimony. I think when the judge was giving the decision, just talked about the status of the visitation. But she was not sworn in to testify.
Status of the visitation and the status of the house, right? She spoke about the fact that they had eliminated some of the concerns that had been found in March. Am I making this up?
Again, I believe that was just after the second day of the 72, when they came back, when the judge in follow up to what the visitation was, that it was at the grandmother's house 1 hour a day.
Ms.
So I don't
Carleen, were
believe
you
there
at
was any
the hearing? Or
I
were
was
you
not, Your
present?
Honor.
at the hearing.
Who was present from the family side at the hearing?
Your Honor, I was present for both days of the 72, what the judge was calling the 72-hour hearing, and the parents' counsel, trial counsel, both argued a motion to dismiss. So to say they didn't say anything in opposition to all of this is just not true. They filed a full motion to dismiss. One of them argued it for both of on both their behalves. I reported to Judge Souza my findings of meeting and interviewing the child, my client, maternal grandmother, as well as the parents afterward, and visiting the initial placement.
Did the mother speak?
I believe the mother was asked questions and did speak shortly. It was
And
not, they were sworn in. I'm sorry, Your
Did she
Honor.
address the question of the current conditions in the home?
Yes, both her and the attorney did.
One of the things that the judge did was say that the department had violated In re Walt and issued an order that had a series of things that the department had to do. Where does that stand? Has the department complied with each of the conditions of the judge's order?
Your Honor, I would refer to Attorney Prescott on this because he is the trial attorney. So I think he would be best to answer that question.
Attorney Prescott?
Yes, Your Honor. I believe they have complied with all of the orders other than the daycare order. The daycare order has been an issue because there's been disagreement between the parents about which daycare the children should go to, and they're trying to work with the grandmother as well because she's in another state, so they're trying to find one close to her in Massachusetts that the child could go to. So they have not completed that part of the order, but they've been working to get it done.
So has the department obtained copies of the parents' Rhode Island DCYF records?
As indicated when she made that order the second day, we have made attempts to get them. We've had no cooperation from DCYF at all. Unfortunately, obviously, I don't have subpoena power over Rhode Island, so any subpoena I sent will not.
Has anyone tried to get the judge's order or anything that the judge said in releasing the child to the parents? It would seem to me that folks on the family side of things want to have done that. And I'm not trying to shift the burden of proof here, but it could be relevant. The department shall submit a referral and implement parent aid services. That's happened.
Yes, Your Honor, that referral has been made.
And have parent aid services begun?
Yes, Your Honor, and I believe they're even trying to incorporate them into the visits.
Parents have been referred to housing specialists.
The DCF has had the meeting with the housing specialist, and they're working to coordinate a meeting between both the parents and the specialist as well.
And I take it at the top, someone advised me that the parents are visiting with the child daily in accordance with 5. All right. Hypothetical question. If I vacated the judge's order, what would happen, Ms. Frizzoli?
The case would have to go back to the trial court, and the parents would be afforded another 72-hour hearing.
Why is that? If I vacate her order, then there's no order that says the children shouldn't be with the parents.
But under
Why would they get?
I'm sorry, Your Honor, under 119, section 24, it's like a separation of powers issue. Once the petition had been accepted by the trial court, the case really can't get resolved short of trial. There are other remedies the judge could have done. I mean, the judge could have himself, awarded custody or awarded.
All right, that's chapter 119, section 24.
Correct.
You're going to have to point out the language. I don't see anything in here that tells me.
And Your Honor, I might have misspoke. I believe you could vacate the custody order, but the care and protection case itself would stay open.
Sure.
So yes, you could, because he had other options, you could either send it back for a 72 or altogether revert the custody order.
All right, that's the way I read this. Ms. Deely, if I vacated the judge's order, what would happen?
Well, I think potentially two things. One, it would return to the trial court, to the juvenile court. And as Attorney Frizzoli indicated, the care and protection case could stay open, although I would dispute that the trial court could not dismiss the case prior to the department's consent or to a hearing on the merits. Section 24 says that that the custody order is pending a hearing on the merits, but it doesn't restrict.
I understand the point. I don't know. I mean, I actually was asking a practical question, but the legal answer is equal too. If I vacated the order, the child would go to the parents and it would stay where? He would stay where? Sorry, not in it.
Well, custody would revert to the parents, as you said, but the department could request, I believe, a new temporary custody hearing. Just as if the petition were to be dismissed, arguably the department could file a new petition.
They might have difficulty with that, where if the conclusion that was reached is that they didn't have enough evidence in the first place. But okay.
Correct. With regards to the jurisdictional issue, if the court could order two things. One, that the trial court did not have jurisdiction to make the order in the first place, and the order again would have to be vacated. Or if you were to find that there was an emergency, you could order the trial court to consult with Rhode Island to find out if Rhode Island will decline jurisdiction. With regards, if I could, I was hoping to clarify a point with regards to custody of Quincy, which is that the specifics of Quincy do not apply to this case because New Hampshire actually had a statute that prohibited them from offering voluntary services, which Massachusetts does not. Massachusetts statute chapter 119 section 51B says that requires the department to provide services to family that needs them. Chapter 119 section 1 also requires the department to make efforts to strengthen families. So there's no requirement that the department have custody in order to provide services to the family.
So let me just try to walk through the alternatives. One would be that I vacate this on the grounds that there's no jurisdiction in Massachusetts. If that happens, the child goes to the parents because the parents are custodial, right?
Correct.
And there's no order indicating that they would go anywhere other than to the parents.
Correct. DCYF.
At which point the child would reside in Massachusetts, but it would be your position that DCF doesn't yet have jurisdiction over the child.
Not unless there was an emergency necessitating their taking emergency jurisdiction. Okay. DCYF could file its own petition again.
I could vacate it on the grounds that there was insufficient evidence to meet the standard of Chapter 119, Section 24. I think that what plays out is exactly the same set of, I would, in that case, would probably decide that there was jurisdiction, although I could skip that to say, I think I'd have to address it. At which point, Massachusetts could go back in, but they'd have an issue because they'd have to show that they had some facts that were different than what I said weren't good enough. Or I could affirm what the judge did, in which case child stays with maternal grandmother for the next 14 days. And then what happens on January 20th, 13 days, when you go back before Judge Souza?
Most likely the court will continue the custody order with the department pending trial, which could be months or years from now, unless the department consents to the dismissal or to a return of custody.
Have you guys been talking?
No, Your Honor, we didn't. We haven't. We received this appeal, you know, I think it was on Christmas Eve. So we haven't, you know, our office has been focused, but I do know that I can speak that this case, we've had numerous discussions with the field and they are looking at this very seriously. And I believe because the parents are cooperating, I mean, I can't represent that a transition plan is existing, but I do think there's discussion about having a transition plan to get this child placed back.
Okay, well, you guys can tell, look, I did not want to wait any longer. The child has been removed from the parents since the child was born, and it's now over 2 months since the removal occurred in Massachusetts. I did not think it was appropriate or fair to delay proceedings any longer. I'm going to have to rule. I think I understand the issues, but honestly, there's some pretty complicated stuff here. The jurisdictional question goes against my instincts, but I do understand the position that Ms. Deely is putting forward based on the language of the statute. And maybe my instincts are wrong. You know, anytime that you ask a judge to be put in the position of overturning a lower court judge whose expertise is in this area, you know, that's a tough call. I'm going to dig into this, take it under advisement, and I will not issue an order for at least 24 hours. I suggest that you guys try to figure it out, because it does seem to me to be the kind of thing that good lawyers can find an answer to under the circumstances. All right. Thanks, folks.
Thank you.
Anything else?
Your Honor.
Anybody else want to, anything that I've missed that I need to be advised about? Ms. Deely?
I will just note that the trial court did indicate that if there hadn't been a reunification by the next court date, that she might reopen the evidence, although I imagine that position has changed since the petition has been filed. There was an indication that she wanted to move things along, but I don't know how that is going to be affected at this point.
I understand that point. Well, I'm not going to prejudge anything, so I understand the point. Anything else?
I just clarify that if you were to vacate the custody order, custody would revert to the parents. The care and protection case would still be open, but the parents would have custody unless you determine that there was no subject matter jurisdiction, in which case the care and protection would would be dismissed.
Right. Agreed. Ms. Frizzoli.
Yes, just if Your Honor does decide to change the custody order, keeping the care and protection open is a benefit to this family, because there are services that we have, implemented based on that reasonable effort order, such as the parent aid, such as trying to coordinate the daycare, trying to, get the meeting scheduled with a housing specialist.
Is there any case you're aware of or that you can cite me to that defines the word emergency in that jurisdictional statute?
Again, the emergency, yes, hold on, Ms. Honor. I believe it's contained in my brief. McDougall versus Akers talks about the child custody, the jurisdiction question.
But what I'm looking for, so the way that...
I'm sorry, and custody of Yvette, I-V-E-T-T-E. Is probably the best.
Y-V-E-T-T-E?
I'm sorry, I-V-E-T-T-E. Adoption.
What's the site?
Adoption of Yvette. Hold on a sec.
And this is going to address what is an emergency for purposes.
It defines, it has the best description of what an emergency, what constitutes an emergency for removal purposes.
Okay.
It's 71 Mass Appellate Court 327.
Okay. Anything else you want to make sure I know?
No, Your Honor, I would
Where I go
rest
off
on our brief.
Do my best. All right. Thank you, everybody.
Thank you, Your Honor.
It's under advisement.